Hello, good afternoon. I would like to welcome you all to our webinar today, Planning for the Future of Cannabis Commerce, hosted by the City of Los Angeles Department of Cannabis Regulation. My name is Dale Sky Jones, and I am the Executive Chancellor of Oaksterdam University, the original and longest running training for the cannabis industry. I'm excited to be your moderator today. And we are here because the Department of Cannabis Regulation has provided the Business Licensing and Compliance Assistance, or BLC program, to assist equity entrepreneurs in the city of LA with obtaining a commercial cannabis license and operating a successful cannabis business. Please visit cannabis.lacity.gov for more announcements on the ever improving BLC program, for new live webinars with different subjects and experts, checklists, worksheets, and other management tools that you can download and use, and links for accessing expert consultants in the BLC coaching program. This connects applicants with seasoned cannabis subject matter experts. We'll drop a link in the chat momentarily on how to sign up for these coaching services, as well as self-directed online education on important topics relating to running a successful cannabis business through the BLC's Learning Management System, which is usually referred to as the LMS. As part of the city's social equity program, DCR has launched this BLC LMS portal where you can access recorded webinars, online courses, and digital resources made especially for the social equity applicants and licensees. I highly recommend that you take this course and explore the LMS if you have not already done so. Also, please check out the pro bono legal services and low bono legal services that DCR, in partnership with the LA County Bar Association, has established to provide legal services. This referral service is available to all social equity individual applicants who have passed the pre-application stage. And before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and it can be viewed after the editing process on DCR's website in the LMS I just mentioned. You will be muted with cameras off for the duration of the webinar. This means your camera and audio functions will not be available during this session. However, you will be able to see and hear the expert. There is an open chat box where you can interact with one another for networking or to comment on the information. And please use caution when sharing personal information in a public forum. Please keep your questions focused on today's topic. And it's best to ask questions about today's subject in the Q&A box. We are gathering and responding to your questions throughout this presentation, and we will have an opportunity at the very end. You are encouraged to use this Q&A box at the bottom pane of your Zoom screen. And if you use that Q&A box for questions, everyone else can also see not just your question, but the answer to the question. We may also choose to answer it live. If you have that question, please ask it because there's probably other folks that do as well. And finally, please note that today's content was not created by the Department of Cannabis Regulation or the City of Los Angeles. It is for informational purposes only. This information is subject to change and does not replace or supersede the Los Angeles Municipal Code, nor constitute legal advice. If you have specific questions outside of today's topic about your situation, please call 213-978-0738 during business hours, Monday through Friday, 10 to 4 p.m., and speak to a DCR representative directly. Now, it is my esteemed pleasure to introduce today's subject matter expert, Mr. Luke Zimmerman. He is the founder and principal of the law office of Luke S. Zimmerman, APC. Luke obtained his undergraduate degree in philosophy from the University of Oregon at Eugene, and then graduated from Thomas Jefferson School of Law in San Diego, California. His interest in international trade and investment law led him to the Netherlands, where he obtained a Master's of Law from the University of Amsterdam, LLM from the University of Turin as well. That is a double master's. And this is on the international harmonization of classification for cannabis trademarks. So he is a cannabis-specific IP attorney. The focus of his first master's thesis was the effect of bilateral trade agreements on the harmonization of intellectual property standards, and he is pushing the USPTO on moving cannabis issues forward. His experiences living in Amsterdam and observations of the paradigm shift surrounding cannabis led Luke to believe that the end of prohibition would likely be the future of the United States. And based on this idea, he formed his law offices the law office of Luke S. Zimmerman, APC, where he assists entrepreneurs like you in the emerging cannabis industry and helps them protect their intellectual property. A core mission of Luke is drug policy reform, which is why he volunteers on the Clemency Project 2014 and currently splits his time between working with clients in California and on nationally trademark issues. Luke is also certified by Oaksterdam University in both beginner and advanced courses, and he is a contributing author to the forthcoming volume, Intellectual Property and Cannabis, which brings together global perspectives on the legal and cultural intersections of cannabis, IP, and law. Welcome, Luke. Please do begin your presentation. Thank you.
Gail, thank you for that wonderful introduction. And it is an honor to be here today to speak to you about my passion and intense interest in intellectual property and how it applies to cannabis. We're going to cover a lot of information today. I'm going to move a little bit quick. My apologies on that. But if and when questions come up, please shoot them to Dale. And I would like to try and address them in the lecture because, as Dale highlighted, if you're thinking about it, there's a good chance someone else is thinking about it as well. So getting into this, the legal structure for cannabis and how it impacts growth, intellectual property rights are one of the biggest growth vehicles in the cannabis industry right now. The simple reason for that being you cannot take cannabis cultivated in any state that has a legal program across state lines, but you can license intellectual property rights across state lines. So that is how we're seeing a significant amount of growth in the industry. And if you stretch it out far enough, that also is true for international expansion, which we're now starting to see. Intellectual property rights matter to businesses both big and small. It is the ability to carve out a limited monopoly in some cases, depending on the type of the right, that allows you to operate and compete with competition. It's important. We're going to highlight how there's some restrictions still currently because of the Schedule I status of cannabis under federal law and how that there's a schism between state law. We're going to touch a little bit on some crystal ball statements about how the end of federal prohibition might look for cannabis in a parallel track for what happened with alcohol after prohibition. And then we're going to highlight just some opportunities that are going to come up for Los Angeles, especially with the Olympics and the World Cup. So because intellectual property rights exist in some cases only at the federal level, and then in some cases both at the federal level and at the state level, there becomes this kind of patchwork issue of trying to pursue and register and protect intellectual property rights. So as of right now, the cannabis industry has to have a strategy, especially of how to move forward to have at least some form of protection. This becomes immensely problematic as it relates to trademarks because trying to protect a brand where you can't necessarily federally register a trademark for anything that is high THC, it pushes you in a direction where you have to register these trademarks in multiple states across the nation. So enforcement becomes really problematic because you're relying on all these different state courts. The California market is a very interesting market. If you're in California right now, you're aware that there are definitely some bumps about the smoothness of operation and pricing and taxes. But California also, from what I've seen, has birthed some of the largest brands that are known around the world for cannabis. So I think there's an opportunity that California has in the industry because of the history associated with California. And how things will change in the future, I've been doing this for about 12 years almost, and I've been saying the entire time we're going to see changes in 5 to 10 years. I still tell clients it's probably 5 to 10 years before we see any movement. But without movement, there's still room to build value with intellectual property rights. As I said, it gives a competitive advantage where you can have limited ownership, or in some cases, like a patent, a limited monopoly. One of the important aspects of intellectual property rights and recording them is valuation. If you are looking to take on investment from investors, or if you're in a position where you're doing a roll-up and you're looking to sell the company, or in some cases, you can actually leverage some intellectual property rights against a loan. there's value. So recording the intellectual property rights, having them organized is very beneficial, especially if you're ever going to put together a pitch deck. And intellectual property is used throughout every industry I can think of in some way, shape, or form. So having the cannabis industry, even though it's still, I would say that it's in its adolescent phase right now for development, the more it uses the tools that are available, the more legitimate it makes the businesses. Um, and it assists, as I said, with expansion into other markets. So these are there are many types of intellectual property or subtypes. We're going to talk about these today. When you hear people say the phrase intellectual property, it's very much an umbrella term. And so underneath that are trademarks, copyright, trade secrets, patents, and geographic indicators are technically even a subcategory of trademarks. Each one of them has their own body of law, their own rules, their own obligations. And so they're very technical in that regard. If you are seeking assistance for this, and this is not a shameless plug, but if you're seeking assistance with intellectual property matters and you're speaking with an attorney who's not familiar with how to handle these matters, find another attorney. I've seen some unfortunate stories from the cannabis industry where attorneys acted a little recklessly and tried to work with intellectual property rights that they didn't understand. And especially because of the federal illegality of cannabis, there's just added restrictions that have to be contemplated when putting together a strategy. Trademarks are the main focus of the practice of my practice. They are source of origin indicators for goods and services. So when a consumer sees a trademark and they engage with that product or service, they know if they are injured, where they can follow back to if they need to have resolution or compensation. And that is the real nature of trademarks. What they have morphed into over time is valuation of businesses. If you can think of any multinational corporation or brand where you could buy the product in the United States, but you could also buy it, say, in Europe and also in South America, that brand identity, that value is really what a lot of companies, like the value of the whole company is kind of tied up in the brand. This is problematic for cannabis because, as I said, the Schedule 1 status under the Controlled Substances Act of marijuana prohibits federal registration for cannabis goods and services because you cannot register a federal trademark for anything that is unlawful. And that ranges from you couldn't register a trademark for, say, cannabis flower that has over 0.3% THC, or you couldn't register a grinder because that would be considered paraphernalia. Or on the services side, you couldn't register for dispensary services because that is engaged in the federally illegal act of selling cannabis. That being said, the industry has come up with strategies on how to pursue trademark registration at the federal level for ancillary goods and services that fit into businesses that are federally lawful. There is an added issue now post 2018 with the federal farm bill, which you can now get registrations for some hemp goods and services that are 0.3% or less THC by dried biomass, which allows for, I can get a registration on smokable hemp flower that's 0.3% THC or less. Because of this restriction for high THC or marijuana not being able to access directly federal trademark registration or protection, this is pushed for the cannabis industry to seek state trademark registration. There are three levels of protection with trademarks: common law, which simply by the virtue of using the trademark in commerce, you have an attached level of claiming ownership or saying, well, that's mine. That's very limited. That is rudimentary in a way where I wouldn't encourage a business to rely only on common law rights. Then there's state registration, which is done at the Secretary of State for every state that has legalized at least medicinal. Some of those states have not updated their state trademark registry, but definitely for any state that has created an adult use program, you can register state trademarks for cannabis goods and services, being the high THC or marijuana type products, which some of the businesses, especially or companies that have expanded into multiple states, their patchwork of state registrations, they'll have registrations in every state they're operating. So it's a bit of a headache, but because of the federal prohibition, it's kind of the best we can access right now. Protecting creative works. This is a copyright, which is an original work fixed in a intangible medium. This covers a wide range of artistic works, ranging from music to film to literature to dance moves. And how it applies really to the cannabis industry is any of the advertisements, packaging, websites, any of the graphic design stuff that goes into it really probably has a copyright that can be attached to it. Copyrights also have common law protection that just by the virtue of creating the artistic work, the right of authorship attaches. But in the United States, if you want to enforce a copyright for infringement, you have to first register the work with the Federal Copyright Office. Doing so prior to having an issue also allows access to elevated damages. So I encourage clients to look at assets that are either high dollar generating, that potentially have a copyright, or we're looking at something that's going to be knocked off. Those are worth registering and registering early. I've also found that because copyright is oftentimes not contemplated and overlooked, you'll have businesses that don't have any sort of copyright inventory organized, but they've actually created a lot of assets. That can be problematic when it comes time to either have an acquisition or if you're trying to have a valuation of your company, because it looks like a zero when in reality, there might be a lot there. I'll also say in the inverse, I've seen some instances where companies hold out that they own all of these assets only to find out that those assets were made by third-party designers and never assigned to the company, or in some cases, maybe there was not a release formally given, so the ownership never really transferred. So this is something that should be contemplated and I think utilized more by cannabis businesses because it's oftentimes overlooked. Trade secrets. So a trade secret is classically, if you think of like Coca-Cola's recipe for the soda, it is a non-obvious secret that provides a financial benefit to the business that really kind of anybody could access, or in some cases reverse engineer. This has been problematic. If you're running a business that you're generating trade secrets, you really want to highlight in your employee manual that your employees who are being exposed to these trade secrets need to understand that they're trade secrets and they need to preserve them. I've seen this become an issue for a few different businesses where that was not addressed early. So then having employees exit and take information with them that it would be valuable to competitors is a problem. So you really want to highlight this. You want to have a method or SOP that you're going to just apply to all of your, hold on, I'm checking my chat really quick because I see things coming in. Okay. You want to have an SOP in place that you treat especially high dollar value or important trade secrets in a way where they're always being preserved, and you're fairly regularly reinforcing that this is something that is a secret and you're taking adequate steps to make sure it's secret. This is a different type of intellectual property in that you don't do a registration. There's not, if you did that, it would pierce the secret and then it wouldn't actually have protection. So yeah, even at times inadvertent disclosure can already pierce the trade secret. So this is something that if you think you're generating, and this runs the gambit between recipes for edibles, client lists for distribution or delivery services, financial records for the business. All these things could potentially be considered trade secrets. So you want to work with that early, especially if you're regularly having employees access information, or if you're in conversations with maybe an investor who is like, oh, hey, I really like how you do that thing. Why don't you just tell me about it and share it? They might just be able to take that idea, especially if you're not taking steps to preserve or protect. Oftentimes, non-disclosure agreements are used in this industry. I've found that some of those are so prolifically used that they're a little bit watered down for what actually the intention of an NDA is. So work with somebody who understands how to do this if your value of your business really is coming from trade secrets. Patents. So patents are a type of intellectual property that require a recording. It is for innovations, be it mechanical or a method or a new type of plant. There's three different kinds. There is a utility patent, a plant patent, and a design patent. You can only seek patent protection for innovation that's novel and non-obvious. So it has to be something that was not in existence, and it was something that actually took like an innovative step from something that might not have existed before or off of an older idea. Patents are one of the most expensive forms of intellectual property to get recorded, but they can also derive a significant amount of value if the innovation is adopted. Thinking about just a hand lotion bottle and the pump on the top of that bottle, someone out there owned that patent. The amount of times that invention was created and distributed and then used through licensing agreements, very prolific for wealth generation. So you want to, this is hyper technical, especially when drafting the patent application. So you really want to work with somebody who knows what they're doing with this. We are seeing more innovation in the cannabis space, both with utility patents as it relates to some of the vape carts and batteries, lighting, and then also in plant varietals under the plant patents, which have to be self-propagating, cloning. You can't be from seed. But I think these rights, so as I said, with federal trademarks, you can't register a federal trademark directly on high cannabis or over 0.3%. Patents, you can register for anything, so long as the USPTO is willing to accept it. Patents give you the right to exclude. They don't give you the right to do. So even if it's something that's federally unlawful, you could still seek patent protection for it, receive a patent, but then not be able to use the patent legally. A patent is a limited monopoly, so you are able to exclude for up to 20 years. And then your invention or the patent moves into what's the public domain, which allows other innovators to use that invention as a building block for potentially seeking other patents. If you are exploring innovation and creating novel new goods, definitely speak with a patent attorney. It'll be worth the time and money, because in some cases, if you showcase or start selling or put the innovation in commerce, you can waive your right and end up having your innovation move immediately into the public domain, and negating any ability to seek a limited monopoly. Geographic indicators technically are in the United States especially, are technically a subset of trademark rights. And the reason to highlight this, especially for California, is California, through the California Department of Food and Agriculture, pursued an appellation of origin program for cannabis, which there is no other place in the world that I'm aware of at this time that has pursued a program like this. It's still not fully up and running, but the value of it would be to say these, if an appellation is granted, the cannabis grown in this limited geographic area was grown with a certain set of standards and potentially from a certain genetic stock in a way that it has a standout value. It has a character to it. It has a terroir to it that makes it different than other products in the market. one of the handicaps with the California Appellation Program is oftentimes GI goods or Appellation goods, they fetch the highest dollar value in market the further away you are from the point of origin of production. And because we have the restriction of not being able to cross state lines, that is a little problematic for the value add. But this is something that I think over the course of the next few years, we're going to hear more of. I wouldn't be shocked if other states develop this or some form of program in some way, shape, or form. I know that there is geographic indication being discussed in other parts of the world right now. So I think this is going to become, there's a kind of parallel to wine about how we're going to see cannabis end up being marketed. And that I think will be on the horizon. So the brand is oftentimes the most valuable asset. I'm seeing this in the market in a way where having some clients in California who are even at times abandoning all their commercial grows, the licenses right now, and just doing licensing agreements to other cultivators, and then doing licensing agreements into other states. And that's purely on the virtue that they have a recognizable brand, a very healthy social media presence. And just because the flower or the hash or the extracts or edibles are being sold in the right packaging, consumers are still purchasing them because they have a goodwill associated with the trademark or the brand. There's definitely licensing opportunities. I see a lot of bridge building going on from the West Coast into New York, New Jersey, and Florida. I'm also seeing some bridges being built from California and Northern California into Spain, and the Netherlands. So, and all of that is done on the brand or trademark. So it's important that like that vehicle alone can be a secondary revenue stream. You have your business, you're running a great business, then adding on these licensing agreements can create additional revenue stream simply by the virtue that you were running a good business. So that's something that definitely should be considered for growth. Shelf space is really hard. There are less brands now than there were in 2018 in California, but there's still hundreds of brands to compete with. And especially knowing that some dispensaries will create multiple brand SKUs and they own all the brands. So it gives the impression to consumers that there is diversity of product, but maybe all those things are really going back to the dispensary owner. So trying to get that shelf space can be very hard. I think that's done usually by relationships, but also by the product speaking for themselves for quality. One of the things I've noticed for the rebrand flexibility, having had clients who will launch multiple brand SKUs of the same flower, but just under different brand names, and seeing which ones resonate with consumers and the ones that don't, they just abandon. And having this as a way, and it's pretty much an identical product. But certain brands resonate and certain brands don't. And we're at a point now where having 5-star cannabis or 5-star product is not in and of itself enough to drive sales. You have to kind of help consumers have this brand loyalty or brand identity. And then I think flexibility of if it's not working, you actually still might have success with the same product, but if we just called it something a little bit different. So building strong local success, I think, is immensely important. It's if you don't have a good market presence and you do not have brand identity by local consumers, it's going to make expansion really hard. And that's something, once again, like it is not only running a good business, having a quality product, but also having a brand or image that resonates well with your consumer base. I think if you are going to build a brand at this point, you really have to do the 2-tier strategy. You have to explore ways that you can have federal registrations and then also still do the state registrations. I've had some clients who've started this process and then said, you know what? I am going to elect to not have a brand. I am great at growing 5-star lead, but I don't want to have to do the additional lifting for brand development, marketing, and they end up white label selling their flower or in some cases their extract to other businesses that then the businesses just use their own branding. And so I think there are places in the industry still where you don't necessarily have to do all these processes, but you are then more reliant on someone else to actually have distribution and sales, that if that relationships becomes not great, that can leave somebody very vulnerable. Um, yeah, so I think another thing to just contemplate is if you're going to go through with this process, you want to start early. And this ranges from doing a clearance search to making sure the name is available, making sure that your name is distinct and unique. There's a issue in the industry where a lot of companies, especially earlier on, adopted the word canna and wanted to have the color green and wanted to have a cannabis leaf in their logo. That's stuff that you can still figure out ways to make it work, but it's also so flooded that trademarks function best when they're distinct and identifiable. And if you're looking at kind of a sea of similar looking brands, you have a white noise effect that really doesn't help consumers identify the brand as being unique. So I encourage clients now to really consider that early, because that can save a lot of headache down the road, let alone if the trademark is already being used in a similar nature in a different state, you're setting yourself up for some form of litigation towards the end of prohibition that is likely going to be costly. So making the most uniquely identifiable brands as you can from the start is really saving a lot of headache and money and potentially increasing value in the long run. Okay, so I talked about all these opportunities that come along with it. There's some risk. I have seen some licensing opportunities that the relationship soured quickly, and it became actually a resource draw instead of a benefit. And with that, I think mapping out who you're potentially going to do business with, slowly exploring, because oftentimes trying to vet a company on the other side of the nation can be, let alone potentially in another country, can be immensely difficult to do. There's also problems that can arise where it's, hey, this is the brand, this is how we do things. And then if you try to kind of cut and paste that into a new state, the regulations of the state don't allow that. And so that has to be contemplated also early if you were exploring opportunities of trying to do licensing agreements. There has to be, these agreements really have to hone in on your ownership of the assets being licensed. So that requires, you have to have some registrations. And that can be, if that's overlooked, you can end up in situations where potentially the licensee ends up registering the intellectual property rights, and now you're going to be in litigation fighting over who actually owns it. So contemplating the partnerships and the structure of the agreements, sometimes the agreement is better to walk away from because it's just going to become more problematic in the future. So, but this is something also very technical. Don't try and do this on your own. There's ample room for exploitation or potential loss of ownership of a brand. So seek assistance from someone who's done this if you're looking into exploring licensing opportunities. The market in California is much different than it was in 2018. And I think adapting to the market, seeing where the demand is very important for longevity of businesses. I mean, as anything as simple as like, should we all keep chasing dessert cultivars or terpene profiles? Should we have diversity? Looking to see where the points of sales, and especially under a brand or brand identity, work. Like if you're in a fortunate position where you own a dispensary and maybe you have 3 or 4 brands that you own, tracking and seeing what's selling, what's resonating, because it has shifted over time and it's going to continue to shift. Um, I think until we hit the end of prohibition, we're not going to see iconic brands that just stand the test of time, that are just like, this is what we do, this is the product. If you buy this hamburger at this location, you can have that same hamburger in locations around the world. The cannabis industry is a very far off from that. So I think it has to, if you want success, you have to be able to be a little bit nimble. You have to be receptive of seeing what consumers want. And it can't just be a force of, well, this is the business I want to run and this is how it should be. You're not your own customer. That doesn't necessarily work. So the big considerations, especially if you're making innovative products, I think this is especially true, seeing how the extract culture and consumers have changed over the last few years. Edibles, I think, have been shaken up in a way too, where at least there used to be a lot more variety of the food stuff edibles. That's really fallen off, both for shelf life reasons, and I think the demand for those niche goods just is not what a lot of the edible manufacturers anticipated it would be. Okay, just tracking my time and do one quick thing. So let's do some crystal ball statements about what the future might hold. And I don't think we have to fully reinvent a wheel, because we've already had the ending of one type of good, prohibition, in the history of this country, and looking at alcohol and understanding that cannabis is vastly different than alcohol and it's vastly different than tobacco. But using, if you're going to plan for the future, try to use something that you can at least associate to give a roadmap, and understanding you might have to pivot and pivot and pivot. But I think there's some similarities we're going to see, and I also think that there's some aspects of the alcohol industry that are going to be hyper accelerated with cannabis. And so things that we saw for post prohibition for alcohol, big brands dominated early, craft came online later. Distribution, owning the distribution channels, and this is where I think there is a similarity that we're going to see for the cannabis industry post prohibition. Distribution is going to be so important, and if you are not in a position to participate with larger distribution, that is going to harm a lot of small businesses, on the basis that we are going to see more cannabis production than we see right now, and will be competing across state lines. So figuring out and tracking that as we see the end of prohibition coming, the distribution side of this is something I would strongly encourage people really to take note of. Regional identity became a major competitive advantage. I live in the Pacific Northwest. I mean, that's still true for a lot of the different types of beer, and some liquor, at least where I live. Local identity became a powerful differentiator. From having seen brands birthed now around the nation and a little bit abroad, what works in the Pacific Northwest doesn't necessarily work in California, especially as it relates to some things like celebrity endorsement, or just even the like vibiness of what the brand is trying to hold out. So I think that's trying to find like a neutral brand that hits the most wide base. I don't think the cannabis industry has really figured that out yet, or the hemp industry. And I think they're like, we're not marketing in an echo chamber. We're not marketing to ourselves. That's going to be something that's really important. But at the same time, there's still always an opportunity for niche market, or, hey, we're not trying to capture the masses or the widest consumer base. We just really want to target people who are into heavy metal and skateboarding. Like, I think there will be room to create brands around that subsection, but it just, especially until the end of prohibition, trying to sort that out is a bit problematic. Um, and I think around the end of prohibition or towards the end, when we see prohibition on the horizon, there's already been an immense amount of consolidation since 2018 for California. It's kind of stalled right now just because of the nature of the market, but it's going to, this whole thing has been a wave in many instances. And I think we're going to see an upturn wave, especially as it gets closer to the end of prohibition, where we can really see some federal guidance. Um, so yeah, that could be maybe the answer for your business is we don't actually want to go through the transition of prohibition because we see that there's going to be a number of unforeseen issues post prohibition. So if we have our business in order, we can be part of a roll up, get acquired, and then get out before. So you're capitalizing on value. So that's a thing to consider as well. I mean, everybody has a different reason for running their business. I'm talking to clients who are like, I want my children to inherit this, to other people who are like, I want to be out in 5 years. I want to maximize as much benefit as I can and value, and then I just don't want to do this for the rest of my life. So I think that's a question to ask yourself while you're running your business is this something I see until retirement, or is this something that has a shelf life? Um, so things that I think are going to very much occur is there is an aspect of trademark law called franchise or franchises. You can think about there's some very identifiable food chains across the nation that are worldwide. Um, we can't do that with cannabis yet because there is a federal regulation that goes into franchises. Post prohibition, we're going to see franchises pop up in a way where we've never seen it before because it hasn't been an option. Um, that is going to become one, you're going to see the increased strength of brand and brand loyalty. Um, and you're going to end up in a situation where shelf space is hard now. And those franchises, depending on the nature of the structure, might even become harder where they only say, well, we actually only sell our products. We're not here for product diversity. We just sell our own thing. Um, so that's something to track. I think, I mean, in the inverse, we're probably going to have some franchises that are like, we are the local market for successful brands in our regional area. And that's what we're known for. You go to, a different state and you still go to our store and you get to see the best of the best for that region. I think that is going to be a business structure that's definitely going to emerge as well. But it's something that should be, I would say, contemplated now, but planned for after we see an inkling of some federal shift in policy that sounds real. There's been a lot of smoke over the last year and a half about things changing. I don't think it's anytime soon. But so yeah, I would say contemplate it now, but it's a problem to address after you see changes are kind of on the horizon. This one is something that I think the cannabis industry will see hyper accelerated. So post prohibition for alcohol, there was an extended period of dominance by just a handful of brands. That's going to look very different for cannabis because that went from federal prohibition with having limited illicit market operation for alcohol versus cannabis, where we have regional industry, we have an entire market, especially in California. So it's like moving into the craft side of cannabis a lot quicker and moving into having the ability then to have those goods shipped to other areas. That's where, like, as I talked about with the cannabis appellation program, that's where I think geographically associated goods are going to have their time to shine. And so I think the idea of building in, because brand identity is very important for this, showcasing why the brand is special in relationship to where it is can be very advantageous in the long run. It's also like if it's done well, it comes through as all like very authentic as well. So yeah, it's definitely contemplation early, but I I'm crossing my fingers that there's more room in the market post-prohibition for small operators to still find their little carve out their little piece. So, but I think that is going to be done by the brands that have a strong brand identity and have brand loyalty. Um, I think, yeah, I just hit a bunch of these points. Sourcing challenges. There's going to be, I think, a point to hone in on is, and this is a cloudy crystal ball, but I think it's just true. There's going to be a lot of unforeseen issues that come along with prohibition. And I know a lot of businesses are struggling to get their feet under them so they can just operate, right? The idea of prohibition is a bonus, or the end of prohibition is a bonus because, hey, we can do interstate shipping, we have access to more rights, we have a more optimized tax issue, but it's also going to shake the board up in ways that we're not even going to see until it occurs. So I think the best way to prepare for that is really just to run a strong business and have, honestly, a strong brand. Make sure you're buttoned up in ways where the things that you want to protect, you own, and you've taken the steps to engage with those rights. Because I think in a turtle-like philosophy, weathering that storm and of transition, it's going to be the businesses that are like set up a very solid business are going to be in the best position. So, but yeah, none of us really know what's going to happen after that transition. So things you can do for internal housekeeping to prepare to be that strong business. I think, especially things that I see along the lines of intellectual property, doing an internal audit, at least occasionally, maybe every couple of years, and being like, hey, have we recorded everything that we think we own? Do we have a running inventory of copyright that we've been generating and using? Have we explored opportunity maybe into other markets? Where are we checking out? Is there licensing opportunities? Make sure you keep great records and then record anything that you think is of value. Without that, you can slow down anything from acquisition to just, if you end up in a litigation situation, trying to recreate records or figure out when things occurred for a timeline can be very cost prohibitive and problematic. So I think one of the ways businesses can run more solidly is just regularly updating these things. So trademarks, register them. Yeah, I think I have not talked, and granted, I mean, they're coming to me for intellectual property help, but I've not talked to a new business starting in the cannabis or hemp space that did not have a brand in quite some time. So that's something that really needs to be complemented or contemplated early. It's something that is going to stand you out from competition. And it's just the vehicle for expansion. So unless you're subscribing to the theory that every city has a place called Donuts and you go there to buy donuts, and that's the method of sales you're going to go after, where it's cannabis sells cannabis, which is an option. You really have to take steps to protect anything that's new, unique. Make sure you're not engaging inadvertently in infringement. That's something that is coming up more and more, especially because the pool of names has been flooded a lot more since going back to the legalization in Washington and Colorado. So that, yeah, but a strong trademark, I mean, consolidation oftentimes is almost majority about acquiring the brand. So there's value here. Copyright, we touched on this. It's the things that you want to know as like niche issues. If you are hiring third-party creatives to make assets for you, and this even runs the gambit of having a website designed on your behalf, unless there's the formal assignment of the work after it's finished, you can end up in a situation where you don't actually own the artistic work. And I've seen that be problematic when trying to do valuation of businesses, where things that were presumed to be owned actually weren't. So this is something, there are unique and very specific laws in California as it relates to independent contractors versus employees making copyright assets. So that's something that it's worth paying attention to, especially in some instance, like the extreme instances is hiring an independent contractor to create copyright works for you. And in some cases that, depending on how the agreement is written, that person could inadvertently become an employee. So this is technical. It's easiest when your employees are making it for you, but you also want to highlight that you own it in their employee handbook. But yeah, I think we're over the next few years, we're going to be seeing more reliance on copyright strategies. It's kind of a easier access than a lot of the other intellectual property rights, and it adds value. So if you are going to, hold on, let me see for time. I got 9 minutes. Yeah, I think the action items now are, if you're in this for the long haul or you really want to increase value, you have to do register, if intellectual property type requires it, you have to do as many registrations, both state level and federal level. I still have and encounter some clients who are like, you know what, I don't think I'm going to end up building a national brand. Then just make sure you're at least doing the state level registrations for trademarks. That those don't really fit well if you end up in a situation where the other side has federal registrations for lawful goods and can pull you into court, because as of right now, there's case law that identifies federal courts won't acknowledge state trademark rights for cannabis just because those are federally illegal, so therefore there are actually no trademark rights. So it's better than nothing, but it's also a strategy that still can leave you vulnerable. Yeah, and I think the last point here, ownership builds resilience for future market shifts, is just, it's that turtling effect of like, if you have a good business, when the winds of change, blow, those are the businesses that hold up. And for having seen a prolific amount of businesses already exit just the California market, let alone talking about the national scope. The businesses that are small, scrappy, but have figured out their numbers, figured out what they're doing, and have built a brand that is identifiable, those seem to be lasting. So I would take inspiration from that as even if you're not generating a ton of wealth, so long as you have a well-run business, I think there is an immense value to that right now. Because you can figure out how to increase that revenue gain. But if it's from a place where you don't really run a tight business, that's not going to be feasible. Okay, opportunity. So, big takeaway from this: do not use any of the Olympic branding, be it the rings, be it LA 2028, in your advertising. Reason for this: these are registered and owned federal trademarks. The Olympics is very good about enforcing trademark infringement. So, does that mean there's nothing to do here and no value? Not at all. It just means you have to get creative about how you're advertising towards that event. Same with World Cup. So you don't want to just drop the rings in there, but there are artistic creativity that could be done where a consumer sees a referential idea without having to be kind of a one-for-one equivocal. So you want to be very aware of that. The other thing that I could see as potential opportunities, because we're going to have such an international community come to the cities, there might just be certain cultures that you're trying to appeal to, or certain regions that are maybe either very cannabis positive or cannabis curious, where they can't necessarily access cannabis in their home country. And I think there's room for creative marketing to go into that. But you just want to make sure that you're avoiding inadvertently infringing on the Olympics intellectual property rights, because they will come after our industry, and just without a doubt they'll win. So that you just want to make sure that you're not turning what could be a bonus into something that's going to be a big financial deficit. Other things that I would consider as this goes on, and this comes from a place of really honing in on education, I would just stress to people from other countries that they might not want to widely share on social media their consumption, because that could be potentially problematic at immigration when they're leaving, or when they're coming into the country. I mean, this would be before your point of contact. They just might not want to say they're going to try some of California's finest cannabis. So, and definitely don't take anything home. So I would hone in on that with your advertising, just as doing some good due diligence to try and protect people who come into your, experience your products or come into your stores. And I think with that, yeah, we're at question and answer time. I have not looked at the webinar chat, so if I have missed questions, now is a time that, Dale, if you want to fire questions off at me, I am great for it. Or where do you see the market going in the next 12 months? I can start speaking to that.
Yes.
I think we're going to have continued market contraction in California. The new taxes that I don't believe have been put in place yet are going to cause more businesses to go under, and we're going to see more atrophy of brands. If we talk about market nationally, there's the opportunity, the most opportunity I'm seeing of money move around is right now in New Jersey and New York, a little bit in Florida. Seeing California brands license into those jurisdictions is definitely lucrative right now. So overall, I don't think there's going to be a change in federal policy in the next 12 months. So I don't think we see the end of prohibition. Yeah, I think California is still trying to find stabilization, and that hasn't occurred yet, in my opinion, since 2018. So I also think that as brands exit, businesses exit, that can create a vacuum, and that can get filled in either by new businesses or by existing businesses taking up that space that is now available. So there is opportunity. I don't see it all as doom and gloom. It just depends on where your business is positioned, and do you have the ability to expand into areas that you see now as an opportunity? Or so, yeah, but overall, I think that it's contraction where with opportunity still. I hope that helps.
Well, let's drill down on that opportunity, because it's going to require a level of strategy. How can small operators prioritize which ancillary trademarks to file first, especially with limited resources?
No, actually, if we roll back the clock to like 2013, the strategy was just get a clothing registration, do clothing. I think that's very outdated, because most cannabis companies are not clothing brand forward or focused. You're not making a ton of different garments. You're not regularly selling garments. So I always encourage clients to do registrations into things that fit naturally into the business. Like if you are going to provide information about the cannabis use or cannabis industry as a whole, the information services classes, which are federally lawful because they're protected by the First Amendment, those are great registrations. There is class 34, so NISE classification system. There's 45 different classes for trademarks. 1 through 34 are for goods, 35 through 45 are for services. 34 is likely post-prohibition where smokable cannabis and smokable cannabis products end. Reason that I can define that is Canada already did this, and we use the same classification system internationally. And then there's a few other countries that have proposed to have that included at the international level. So getting class 34 registrations, I think, are very important for businesses that have smokable cannabis products. Right now, probably the most prevalent strategy there is if you white label produce hemp cigarettes, you can get a registration that, in my opinion, is fairly equivocal to what we're going to see after prohibition ends. So for small businesses, the other thing I would strongly encourage is don't exceed your budget. I've seen some companies start out with, we want to file trademark registrations for a wide berth of things. And by the time the trademarks even register, they already like, we're not using 3 or 4 of these anymore. So I think having a clear understanding of what you're building, and then I subscribe to what I consider like the money faucet principle, which is if we're turning on the faucet, what good or service is providing that money flow? And then you can use that money to then fund the kind of other projects. So every license type has a little bit of variation of what the important classes are, but 34 is like the high dollar value class, in my opinion, in the long run.
And last question, before we start to wrap, what are the small, affordable first steps to start protecting your IP without spending a fortune on legal fees?
Right. So each type is different. If you have an innovation and you're like something that could be patentable, you kind of just have to like bite your, grin and bear it. Like the expenses are going to be worth it in the long run because it's hyper technical. If you are looking at trademarks, there are resources at the Secretary of State that will at least give you a good FAQ overview. And I mean, if you felt confident maybe forming your own entity, there are things that I think people can do on their own. I would not encourage doing that as much at the federal level because it gets to be a little bit more technical. And that also, depending on how you initially file, you could have an application be dead from the moment you hit like submit. So I would say look at state resources for trademarks, copyright, just on the nature that you have common law protection that is attached if you're the author. You can just even organize that and just create the inventory. Maybe you're not even seeking registration for those things at that time. So, and I guess the backdrop to each one of these scenarios is just knowing what you're doing and being able to identify the different types of intellectual property. Because I've definitely spoken to a number of people who are like, oh, I have to protect my IPs. And then when I ask what do you mean, they don't have an understanding of the different types, which if you can't identify where it fits, you already are you're not understanding the tool. So unless you can clearly see what is in front of you of like, these are the things I'm engaging with. Yeah, that is the foundational across the board. That's like the first step. Just understand what your business is and understand which types of intellectual property are going to intersect with what you're doing.
And then be able to defend that. All right, last quick
Well, that's right.
question.
I mean, that's right. That is the starting point. Then do the registrations. That's where you get a lot better with your defense. But yeah, I think identifying the issues first is really the first step.
And I'm going to sneak this under the line about if someone's already using their branding or mark without a trademark, is it too late to protect it, or are there steps you can still take?
No. So trademarks, I mean, I have some clients who come to me 3 years after they've started using the mark, and you can still do registrations. What is problematic in those situations are there's a question for the clearance to see if doing a search, you find out that there are competitors using the similar mark. That creates a situation that sometimes immediately goes into rebrand, or it's a situation of, are you willing to litigate? Or it's in a situation of, well, you were the first one to do it, so arguably you have the superior claim to the right. But if they come knocking and there's a fight that's picked, are you willing to spend money on this? So it's its own cluster of questions and potential issues. But if you haven't sought protection or registration at this point, I still encourage you to explore that. Because sometimes that can even just preemptively stave off a bigger problem down the road. We are like, oh, I didn't realize that I was infringing. I don't want to have to litigate this thing. So it would be less expensive for me to pivot right now than to push. So no, I mean, you can work on intellect. The only type that really is prohibitive, or only two patents, if you've already shared the information or shared the innovation, and then just taking no steps to get like a provisional patent protection, then it probably is moving into the public domain. Or with trade secrets, where you share enough information and then you're like, oh, it's not a secret anymore. I can't undo it. But copyright and trademark, you can be well into use and still seek registration and elevated protection for those types.
Right on. That was amazing. And we did get a question about, all of us pulling out our crystal ball on when prohibition will end. And
Mhm.
without taking bets, I think it's also important to realize that prohibition ending is not a switch that'll just flip one day. It is going to be a process that is going to take time. So even when the decision is made, almost every state in the union also has a Schedule One law, including California, that will need to be repealed and replaced. For instance, anything you want to end with on that question?
I think, I mean, as cheeky as the answer is, it's still 5 to 10 years. It's, and I remember starting my career and talking to some of the old timers who are like, I've been doing this for 30 years already. And the fact that we're now just seeing some of this change is amazing to me. But I thought it was going to be in 5 years, 30 years ago. So I would plan for what's in front of us, and that for a business of like focus on the market that you're in or the markets you hope to expand to. And I think as the rumblings of federal change and prohibition ending, we hear them, then start planning for it. I think jumping the gun and trying to make some of these moves that are maybe dependent on that, that could be a value suck and a resource suck in a way that you're just now holding your breath and treading water for something that might take a long time to get there. So
And
I hope this,
remember,
go ahead.
y- finish your thought.
No, I was gonna say, I hope this was informative and educational, and I hope I know I talk really fast, especially on this topic. So yeah, I just want to say thank you for letting me speak to you today, and it's been an honor.
Right on. Thank you so much, Luke Zimmerman. And thank you all for attending this amazing informative webinar. I know I learned a lot. And thank you to the City of Los Angeles Department of Cannabis Regulation Social Equity Program for putting this on. And, don't forget, attendees, sometimes your size is your strength, and being small makes you nimble and swift and in response. So hold on to that little hit of hope. This webinar recording will be available on DCR's website, cannabis.lacity.org. If you have any questions on accessing your LMS account, please email dcr.sep@lacity.org. Also, friendly reminder, you can still get your amazing professional business coach. These folks are here to help you succeed, your business and you as an operator. The next webinar is Local Consumption Lounges discussion with Courtney Lang and Jason Colleen on May 13th. And my name is Dale Sky Jones with Oaksterdam. I'm so grateful for your time and attention today. Thank you again for joining us. Thanks to Luke Zimmerman, and thank you to LADCR. I hope you have a wonderful rest of your day.